You can stop calling the county clerk, okay, and the city clerk's office, because I'm going to answer your questions right now. In the United States, there's been a huge effort in order to defund the police. That does not mean that your ability in order to file a grievance, whether it be against the police or someone else, is hampered in any way. For some reason, and it has been several years, in Illinois is under the same impression, that the average person cannot file a criminal complaint. Absolutely false. It's exactly what is supposed to happen. Now, if you need a police or a sheriff, well, they got a gun, they come in and they make sure the piece is handled. But they're supposed to take, quote, your complaint, not your statement. However, the police don't give out complaints anymore. They don't grant a complaint. Well, it's not up to them to grant it. So the clerk's office is getting way too many inquiries concerning whether or not someone can file their own complaint now. It's getting ridiculous. So you want to find out whether or not you can file a complaint and how to do so. You can take your inquiries up with the Secretary of State rather than the county clerk's office, okay? That's where it's appropriate. Fact is, without the Secretary of State, I wouldn't know for absolute fact, okay, that I can file a criminal complaint. Now, just simply because the police did not file, it doesn't mean that it's not a criminal complaint. In fact, with defunding the police, does that mean that unless the police does respond to you and the police makes that report, does it mean that no crime was committed then? Does it mean that? No, it means just that there was a police contact, okay, was not achieved, but the crime was committed. You come by, you bust out the spokes of my bicycle, and the police do not have time in order to mess with you because they had a gang violence that happened a couple blocks away, and we've got something else going. You know what? That phone for the police just does not stop ringing. Now they don't have time for it because of this. Now they don't have time because of that, and it can be pushed aside. That doesn't mean that you don't have a right to file a criminal complaint. This has actually captured the attention of a lot of the lawyers here in town, especially defense attorneys, because that means that people are there's going to be a boom in complaints as soon as this procedural issue to today's standard is resolved. The fact that you can is not in question. How is in question. What paperwork do you fill out? What is the process? And being the fact that it is a criminal complaint, there is no filing fee. However, the clerk's office is, for some reason, restrained from accepting a criminal complaint from an average person, according to their current interpretation. Ladies and gentlemen, this may go to the Supreme Court, Colorado Supreme Court. They could not, through any mechanical or filing method, remove your rights to file a complaint. It's as simple as that. And whether that's criminal or civil is not for them to declare. It is for you to declare, the witness to declare, the victim to declare. Let me tell you something. People that are out there complaining about sex offenses and stuff like that, where the police have not even filed a complaint because they refuse to do an investigation. Ladies and gentlemen, you have the ability to file a complaint. You don't require the police to do so. And under those circumstances, the fact that you went through the effort of actually filing the complaint, and don't forget, you are liable for filing a false complaint. That's what a false complaint is. So, I wasted a trip into town this morning. I have to go home and write a memorandum as concerning procedure to allow the judge or the magistrate to, one, not obstruct the official process, but two, find out if there's a clog somewhere in the drain of the official process. There's a blockage, and it's somehow lobotomized half of the function of the clerk's office. Intellectually, these people are engaged. It's an interesting problem. It's something that is being ignored nationwide, and nobody's pursuing it. Well, that gets scary. Now we're talking about Eric Brandt territory, aren't we? Eric Brandt deserves praise where praise is due, and he deserves criticism for where criticism is due. People who wish to speak out against me do not use such discretion. Yeah, I have to check today. Today's Friday. If I don't do it today, I'm not going to be able to do it this weekend. I have no reason to come to town. I have food. Actually, I do have, but I have food. I have my necessary things for life. No reason to leave. I've got paperwork in order to do, so I need to go ahead and take care of one of my town chores real quick. Anyway, the issue is that the clerk's office cannot accept it according to what they're saying. There's no procedure that does not allow the prosecutor's office the discretion, because the action is still the people. Even if you, as a citizen, represent the people, which you can as a citizen. You can represent the people of the United States because you are the people of the United States. You are the government. It's our fault, not the government's fault. You got to get that in your head. We allowed it. That's what the issue is. So, what is happening? Well, I've got some of the strongest bars right now with Verizon Wireless, so if I have any problems, I'm going to be upset. Anyway, yeah, we're going to have to take care of that. Oh my God. Should have brought my Bluetooth so I could talk to you on it. But yeah, there's some details that you actually need to know, and I need to bring that to you because basically, whatever this is, I am the liaison, okay, in order to find out what's going on. Whoops. Uh-oh. You need to let me tell you what's going on and the procedure that we're coming up with. The issue that we're having is that the prosecutor's office still has to have their discretion for the benefit of the community. They have to make a communal decision. So the way I'm doing it would remove their discretion. Well, to a certain degree, I agree with that, but at the same time, I don't. Now, I'll explain that in a minute. Anyway, all right. Now, this is what's going on. We have Rule 4. If an affidavit appears before a judge or a magistrate, a warrant must be issued. Complaint and affidavit purporting a crime. So, just the mere fact that a prosecutor is the one that submitted it does not change the fact that it's a complaint with an affidavit. Anyone can file a complaint and affidavit and have it appear before a judge, meaning that anyone can get a warrant. There's a problem there. No one's been doing this for so long. They actually don't. Whoa! So we've come up with 2 or 3 different procedures. One was that we file it as a criminal complaint that would then go directly to the district attorney's office, not the judge, so that the district attorney is not bypassed in the approval. Now I've got dog. So that the district attorney won't be bypassed in the approval process or the discretionary process to prosecute. That's necessary for people, let's say they're a witness to Al Capone or something, made a deal with the state. That doesn't exonerate them from the charges that you file. The charges that you file would just simply be among the charges that they could, but they can actually negotiate out of that. From the prosecutor's point of view, you have to maintain that ability for negotiation on the behalf of we the people. I would be acting on the behalf of we the people. So we have an equal standing in the consideration of we the people, meaning that the prosecutor cannot be taken out of the loop. But there is nobody that disagrees that a criminal complaint now. The way that this is set up currently is that it would go to the clerk's office, then go to the judge, which bypasses the prosecutor, which creates a problem. So you can't file it directly with the prosecutor. There's no function at the prosecutor's office in order to accept it. The only function in order to be able to accept it's the clerk's office. So how do we get it from the clerk's office in the format of a criminal charge to the prosecutor's office for consideration and use of discretion? And what happens if the prosecutor does not accept that charge, however a warrant is issued? You see what the problem is? We got the judge in the wrong place for the procedure. There's a lot of people that is interested in this. They're not on YouTube, they're literally at the courthouse. I have the attention of a couple of DAs that are trying to figure it out themselves because, I mean, in all logic, that's exactly what's supposed to happen. Unfortunately, the mechanics internally with the clerk's office is not the case. I got a professional idiot up my ass.